All right, hello everyone, and welcome to our second episode. It's not really an episode, it's more a video, a lesson. Calling it an episode is kind of weird, but today we're going to be talking about methods used to resolve a civil dispute. So we're getting way on from talking about principles of justice for the thousandth time, and now we're going to be talking about how they actually go about resolving civil disputes. And part of the reason we go into this is that the aim with most civil disputes is to never get to court. So we're going to be looking at some of the avenues they take to try and make sure that a case never gets to court. Some of those are mediation, conciliation, arbitration. These might come up in other subjects, like if you're doing business management, I'm pretty sure they come up at some point. But we're going to go into them in more detail here, look at some strengths and weaknesses of them, and then look at a couple of practice act questions along the way too. So strap yourselves in, it's going to be a fun ride. All right, so some learning intentions and success criteria. So we're aiming some methods to resolve civil disputes such as mediation, conciliation, and arbitration. And our key skill is to describe the institutions that resolve civil disputes. So we want to be able to identify and explain 3 methods used to resolve civil disputes and to evaluate the effectiveness of each method by their strengths and weaknesses. You should already hopefully know by that, but with each of them, it's going to be strengths and weaknesses. That's going to be a discussed question on a SAC probably. So let's get straight into it. So mediation. Mediation's the first form of dispute resolution, and it's also like the least full-on, like the least serious of them all, but it is one of the most commonly used, the most commonly recommended, and mediation is a cooperative method of dispute resolution. It's where 2 people come together with an impartial third party, and the third party doesn't do anything other than help facilitate the conversation. They don't make any suggestions of what people should do. They just get the 2 parties to talk so they can hopefully come to some kind of agreement. So mediators aren't experts in this particular type of dispute, and they do not make the decision. Through negotiation, the mediators negotiate with parties to help them reach a compromise. So if the parties agree to a solution, they normally enter into a legally binding contract called terms of settlement, and mediation can be ordered by a court or tribunal or organized privately by the parties. So that's mediation, 2 people coming together with an impartial third party who helps facilitate the conversation to get them to a hopefully beneficial resolution for both parties. Another method is what we call conciliation, which is almost exactly the same, except that third party can make suggestions and they have expertise in that particular area. So like mediation, conciliation is a cooperative method of dispute resolution, but the process is also overseen by a neutral and impartial conciliator whose role is different to that of the mediator. I'm sorry, Aria's here to hang out, so let's just see what she's doing. Hey Aria, what are you doing? Hey Aria. And as you can see, my rule of I only ever do this in one take is going to continue. So hope you enjoyed that 1 second of Aria shaking. Oh, she's back. And now she's bailing. That was all she wanted. She just wanted one pat, and then she went off to enjoy herself elsewhere. So the suggestions that conciliators make are not binding. If the parties accept the suggestion, they usually enter into a terms of settlement. Like before, they sign a legally binding contract, but the suggestions made are not binding. That's kind of similar with mediation. If they just come to an agreement and don't sign a terms of settlement, it's not binding. And so conciliation is usually used by the courts or tribunals and other dispute resolution bodies as an avenue to prevent getting to court, because you're coming to a solution before going to court. It's going to save you time, it's going to save you money, it's potentially going to protect the relationship of the 2 parties, because if you go to court, that's likely to be destroyed because we have an adversarial court system where 2 people go against each other and one's going to win. Whereas conciliation, mediation, it's aiming for both parties to win, because you're coming to a solution where both people are happy, or hopefully happy, and it is going to be the best overall way to get everyone's rights to not be infringed anymore and back to their original position. So some strengths of conciliation is that the parties reach the decision themselves, so they're more likely to be satisfied with the outcome. It's an informal atmosphere and less confrontational approach, so no examination of witnesses. This can help with the ongoing relationship of the parties and relieve any stress for the parties. Matters can be explored fully, as process is private, public publicity is avoided, and information is not disclosed or used against them. Specialized knowledge of the conciliator will allow them to guide the parties to a resolution. So that's meaning like if it's a construction case, the person there is an expert in that area, so they can actually make suggestions based on it. Whereas if you just had a random third party come to a construction dispute, they'd mention something, the person would have no idea what it's about, and they couldn't actually help them. And there's flexibility regarding solutions. Like, it doesn't just have to be money. It doesn't just have to be finishing off a contract. They can come to terms that are unique to that specific case and that they're both going to be happy with. So if both parties are not willing to compromise, no agreement is likely to be reached. That's one of our weaknesses. Basically, you might just get one person. You've probably been in this situation where your parents have been trying to negotiate between you and a sibling, and you've just sat there and just like, no. No matter what they suggest, just like, no, not doing that, no, I'm not doing that. And so if you're going to be like that, no one's going to get to a solution. If a terms of settlement is not signed, the outcome's not binding. Neither the mediator or conciliator have the power to make the parties reach an agreement. So the conciliator can make suggestions, but if they don't go with that, nothing's going to happen. It does not suit the complex disputes where one party has a stronger position overall. So in some instances, it could be a workplace dispute, and the boss might overpower and just kind of like, not threaten, but like use their status to try and convince the worker to agree to whatever terms they're saying. And the absence of legal representation means that some parties might be dominated. Similar kind of thing. Someone might just be more domineering in the conversation, and therefore it might force them into a solution that they don't agree with otherwise. So, evaluate the ability of mediation to achieve at least one principle of justice. Well, what could we talk about here? Well, we're going to be talking about strengths and weaknesses, and we could talk about really fairness. If we talked about fairness, we could talk about the fact that both parties should have the opportunity to present their case and have everything said. So an advantage of mediation is that both parties can freely speak, and the third party, the mediator, will help them get, like, both parties be able to have their say. So that's fairness. That's going to be beneficial. Disadvantage of this is that, similar to conciliation, one party can dominate the conversation, and therefore it might not actually help fairness be reached because one party is doing all the talking and trying to force the other party into a decision overall. So then lastly, we've got arbitration. So arbitration is kind of like the most formal alternative dispute resolution process. It's where an arbitrator, who's essentially like a judge, is an independent third party who listens to both sides of the dispute and issues a binding decision called an award. So in this case, it's the only case where the third party makes the decision and that decision is binding. So it's more formal than mediation and conciliation. Witnesses can be called to answer questions and evidence can be tabled. Arbitrators are often experts in the subject of the dispute, and it's often used in commercial or corporate disputes. And so all civil claims up to $10,000 filed in the magistrate's court can be solved by arbitration if agreement cannot be reached by the parties. So they can award damages up to $10,000 or awards up to $10,000. Anything above that does actually have to go through the court system, but that is how arbitration can be used. So some advantages of arbitration. So some strengths is that the decision's binding. So that's really good because there's going to be an end to the dispute. The downside of that is parties have no control of the outcome. So it's less likely to be a win-win situation because in this situation, one party wins. So if you're that party, that's great. If you're not that party, you're going to be a little bit upset and also slightly poorer. It's less formal and expensive than a trial process, but it's also more formal and more expensive than mediation or conciliation. The arbitrator normally has expertise in the relevant type of dispute, but it's not always available as a method of dispute resolution, and it can take a long time. So there can be some time lags before it actually can happen, which can make the dispute actually get worse. If it lingers and festers, it's going to be a more like angry dispute, and therefore it could be harder to come to a solution that both parties agree with. It allows for more flexibility in the process, and it is also private and confidential, which is great. So then we're going to look at another question. So which method of dispute resolution is best for solving disputes between neighbors, and justify your answer. So if we look at two neighbors here, highlighting is not going to work there. Let's get some white. I don't know what I was drawing there, but let's look at a person like this, give them some arms, give them a happy face, and the neighbors over here on the other side of a fence, give them a face too. I don't know why they're so happy because they're about to be angry at each other. We can fix that up in a second. So this guy is playing loud music all the time. Playing so much loud music. Is a dispute between neighbors, and more important things are happening. I'm going to pause this for a second. All right, I'm back. Sorry for the delay. Rach had very exciting news that one of our very good friends had just got engaged, so that was very exciting, and we reacted to that appropriately. It was a little bit like this for like a good couple of minutes, and now we're back to talk about the noisy neighbors. So we've got a neighbor here that is noisy, and it is making this other neighbor not very happy. So we get rid of his smiley face there. He's a bit upset now. Which method of dispute resolution would be best for solving this dispute? Well, I'd probably argue that first up, mediation is going to be the most important here, because it's a pretty simple issue overall. And if they can come to some kind of agreement, it's going to solve their problem very quickly. Conciliation is going to be a bit like, you don't need an expert in that situation. Arbitration is a bit full on. Like, this is not a case up to $10,000. You don't need an arbitrator there to make a decision for them. So mediation is probably going to be the best there, because it's going to preserve their relationship and hopefully get an outcome where both parties are going to be happy and they can come to their own terms, and it will be best for everyone overall. All right, so that's it for today. What you're going to do is the fun of filling in this table, which you will have on Teams already, so enjoy that. Other than that, it's always good to have you watch me talk to you pretending like you're actually in class, and I hope you have a wonderful day, and I'll no doubt talk to you in chat when you're like, this is too much work or this doesn't make sense. So I look forward to that. Have a great day. Goodbye.